Hi, my name is Bob Warach, and we call this series The Docket. We'll be discussing legal issues that affect the borderland and often the country as a whole. Our hope is to present these issues in a clear and concise and understandable format, but as always, I need to make the disclaimer that neither I nor anyone else involved in the program is giving legal advice. These programs are informational only and hopefully will spur conversation about the topics we discuss. For those of you who are new to our viewing audience, I want to let you know that we tape our programs at the El Paso Community College television studio and depend on the college not only for the physical space it provides, but also for the intellectual and educational support it gives us. So thank you, EPCC, and let's get started. I have two outstanding guests here in the studio today, Judge Robert Achondo and Ray Duke. Judge Achondo has been on the bench for 16 years, and Ray's been with the District Attorney's Office for 17 years, and has been doing alcohol-related offenses for the past 6 years. So both of them have a wealth of experience in their respective positions, so let's get going. Thank you both for coming and helping me and the viewers understand what's involved in DWI prosecution. Now, Judge, this isn't actually prosecution, I don't think, but it's my understanding you developed a very unique DWI treatment program that's been nationally recognized. Is that right?
That is correct.
So why don't you tell us about it?
Well, first of all, it's always good to be here. Good
Thanks.
to see you.
Thank you. We've known each other for a while.
We have,
yeah.
So I appreciate the invitation and an opportunity to tell your viewers about a wonderful program that was created approximately 14 years ago to address a very serious problem that is not only prevalent here locally but nationally, and that's alcohol.
Right.
So what we have determined, research and experience, previously when we were dealing with alcohol-related offenses called DWIs, driving while intoxicated, we weren't really handling, I believe, in the best posture that we could to help some of these folks address what is a serious illness. I call it a population that can kill.
Right.
Because, you know, they're driving a vehicle.
Yeah.
And I think most of your viewers, if not all viewers, have heard how serious these offenses can be. So it's a post-adjudication that basically means that it is determined after a discussion with defense counsel, the state, that the individual probably would benefit from entering a program that is in phases. It's a 14-month program. It's regimented to have a lot of treatment component. The courts then oversee it to make sure that the person is complying. And during the term of assessing an individual, we have to assess. In other words, when you assess an individual, you're going to determine what services that person is going to need. We're going to be dealing with persons that have a high risk and high need.
Okay.
That's our population that we work with. High risk because of what they pose to the community. High need because of the assessment and the seriousness of what they have, and we've determined that they have. They're going to need a lot of treatment over the course of over a year.
When you say post-adjudicated, that means after they've been convicted. Is that right?
That is correct. The program is designed, one program in other words. It would require too many resources. So the agreement amongst the Council of Judges is a program is created to help those courts who see a case that would benefit from the program. Then it is transferred over to our court.
I got it. Yeah. Okay, that's what I was getting at.
Yeah.
So they would then transfer it to you, and that's where the treatment.
Correct.
Okay. All right. I didn't mean to interrupt.
No. It's somewhat complicated, but I didn't want to complicate it with your viewers. There's an agreement amongst our judges, both at the misdemeanor level, at the felony level, and with our federal partners, to be able to determine if the individual would benefit from the program from an onset of an assessment, in other
Right.
words. And of course, a lot of discussion is undertaken between counsels before this happens. And so what happens is once an individual is now entering a program, a treatment plan, a continuum of care is now being determined for the person now to start participating. And what we've now developed is a component to deal with the families, because we've determined that, of course, families need the help. A lot of family members don't understand what's going on. There's a lot of family members that don't understand the disease of alcoholism.
Right.
And so what we're trying to do is also not only help the offender, but help the family. When I say a program is going to have a regimen of things. There is what you call Alcoholics Anonymous,
Right.
Narcotics Anonymous, peer support groups, counseling, family support, a lot of things that we're trying to do with
That
an
are
offender.
components of your program.
That's correct.
Okay.
They all complement to determine and provide all the services necessary that an individual needs for those that need it. Because since alcoholism doesn't discriminate, we have professionals, you have your medium individuals, you have your low-end individual, you have your laborers. So we deal with many, many individuals because of the seriousness of the offense. And that's how basically it's working.
So are there social workers involved in this?
There's social workers involved. Well, this is what your partners. It's basically a multi-disciplinary team. This
Right.
is this is what it consists of. Once an individual is coming into a program, they have the judge, of course. Then you have a case manager. Then you'll have a social service worker. Then you'll have probation involved. Those are the individuals going to make sure that they're following the court's orders and the program requirements. You have the district attorney's office who's participating as part of the team. You have defense counsel participating in the team to make sure that rights are being protected, the Constitution is being adhered to, things of that nature. We have the benefit of having law enforcement. Law enforcement comes in because they do a lot of our surveillance. They're making sure that when they're visiting these individuals at their homes or place of employment, that they are sober, they're not intoxicated. And they also get to converse with family members while they're visiting at the home. Then you have your other components, which are a lot of your treatment providers that we have in our community that help with providing the dosage of treatment that these individuals need weekly by way of one-on-one or group sessions, things of that nature. And so these are phases. Each phase requires certain things to be done and completed.
So what criteria do you use to determine whether somebody is appropriate for the program?
Well, you have disqualifiers. Of course, persons that have aggravated offenses could pose a problem to team members. So we may not take those. It's a case-by-case basis. Somebody charged with arson, somebody charged with murder, maybe they're not the appropriate fit for this program. People have to live here. We have our sister city over here, Ciudad Juarez.
Right.
So folks that would live in Juarez, it'd probably be difficult because their surveillance can't go across.
Right.
Then we have our other sister city over here, Las Cruces, New Mexico. So we have people that live in Las Cruces. So sometimes it becomes very difficult because the offense occurred here, but they live in our sister cities.
Right.
Makes it kind of complicated because I can't stretch my jurisdiction out.
Right.
So that's limited. So what you basically have is your second offender that's had a DWI is probably going to be a good fit. Person that's probably had contact with the criminal system, even if a case has been dismissed before, comes into the system now, may be a good fit. We look at the lapse of time, how long ago maybe an offense was before this recent offense. Those things are taken into consideration. And so those are probably your qualifiers that come in.
How long is the program?
14 months.
And when they're out of it, the end result, I'm supposing, is that they don't use alcohol anymore.
We hope.
Okay.
We certainly have
Right.
given them and their families or their support system enough tools to be able to handle those triggers they may have had in the past.
So they're going to want to have to do this. They're going to want to have a desire to do this to better themselves because they've already been convicted.
That's correct.
And this is not going to eradicate that conviction. Just hopefully they come to an understanding of their problem. And
What you have is you can voluntarily say, I've hit bottom. I'm just not going anywhere.
right.
I do need help. And some of the other courts that we work with mandate it as part of
They come over to your program.
That's correct. They could be on community supervision called probation, for what your viewers will understand. And so they're not making it on probation. They're violating. They continue to drink. So we need now an alternative. Option is you're going to go to the intervention treatment program. And so that's an option.
So when you said like the defense attorney or the prosecutor, would Ray say to you, I don't think this guy is really appropriate?
Sure.
Yeah?
Yeah, sure they can.
And but do you make the final decision?
I can, but I'd want the input.
Right.
I want the input from many, many people. Ray can certainly give me the input. Defense counsel can give me input. Our coordinator who does a brief assessment can also give me some information that I need. So based on all that, I've made that decision sometimes to accept someone. So this is an alternative to probation.
Right.
This program is more intense. In other words, your traditional probation is an officer having a caseload of about 120 individuals. Well, we know that with the resources we have, it's going to be very difficult to handle this population, knowing full well that a probation officer has many, many other cases from many other offenses. Here in this program, once we identify that this is truly the problem, because alcoholism can also be a traumatic event, so people probably have been drinking and masking the trauma for many, many, many years. We're now going to be more intense. We're going to be more specific related about an offense. So we're targeting. So our probation officers that work would have a caseload of about 40, 45 individuals. Lesser caseload, more attention.
Yeah, of course.
We are now identifying and trying to correct the problem.
How long has this program been in existence?
14 years.
So really, you developed it right soon after you took the bench.
This is how it's the first one in Texas.
Right.
I know that when I started this, there was maybe 300 in the country. And so we're very proud that we've been nationally recognized.
Right.
And I credit that to our community, the support, and our team members that we have for that.
How have you tracked the success?
Good question. We've just been evaluated. We've been evaluated, and we have a 6% recidivism.
That's all.
Yeah.
That's terrific.
Yeah. We're very proud of that.
Yeah.
That means that we're doing some good work, and we attribute it to the folks that have graduated from the program that they're doing well.
Well, attribute it to that, but attribute it to you too for developing it and instituting it and getting the community involved in it. I think that's pretty impressive.
We think so.
Yes.
We're very proud of that.
Good. Okay, Ray,
Yes, sir.
you are a prosecutor.
Yes, sir.
And do you prosecute in Judge Achondo's
And yes, I do prosecute in Judge Achondo's court.
and others?
And other courts around the county as well. I have recommended people into this program. We look at the defendant's record, and we look at the offense itself, and we make that determination. And then Judge Achondo actually has a coordinator that interviews the defendant before they're allowed into the program to make sure they're qualified, to make sure they're a good fit for the program.
You mentioned to me, again, before we came into the studio, that perhaps there can be 80 or more occurrences of this before somebody might get picked up for DWI.
Absolutely. The studies have indicated your first arrest is about your 80th time that you've driven while intoxicated.
Yeah, I mean, I find that absolutely overwhelming.
Research is indicating 80 to 200.
Yeah, it's crazy how many times you actually drive before you're arrested.
In your rural communities, it would be like 600 times before they're picked up.
So I want to get back to you, Ray. I don't do this kind of law.
Yes.
So I'm going to ask you a very basic question. What's the drinking age?
Drinking age in Texas is 21 years of age.
Okay. Which is older than the age of majority, the age when you become an adult.
Correct. And in Texas, for criminal purposes, for adult prosecution, you can be held liable, held criminally culpable, if you will, at 17 years of age.
Oh, is that
in
right?
Texas. Yes.
Is that across the board, or does that depend on the individual?
17 years in Texas.
Wow. I want to talk to you about the alcohol level. Everybody, whenever there's a DWI and you read something in the paper and it's, oh my God, this guy had an alcohol level, or this woman had an alcohol level of whatever. What is the alcohol level when you're considered to be driving while intoxicated?
Yes, Bob. In Texas, the per se limit is 0.08 or greater at the time of driving. You are legally intoxicated. And that's just one way we can prove intoxication in Texas.
And what are the others?
The other two ways we can prove it is through the loss of the normal use of mental or the loss of normal use of physical faculties.
And how do you prove that?
Well, you can prove that by the driving facts themselves, by the interactions with the officer, by the interactions with other people at the scene. Those are the ways that you would actually prove that. And as far as the law enforcement goes, they actually use a standard set of what we call standardized field sobriety tests that help an officer make that determination whether they've lost the normal use of their mental or physical faculties.
And cameras, body cams or cameras in cars, are they depended on?
While I would like to say that every case has a video camera,
Right.
that is not necessarily true. I know a lot of our departments have video cameras in the vehicles, and a lot of our departments now have gone to body cams, and I certainly encourage the use of body cams as well. I think it's a great tool not only for investigative purposes, but also for the jury to see as
Right.
well.
I mean, I would think it'd be incredible for the jury to see it
Absolutely.
rather than just oral testimony about what happened, because then it's like he said, she said.
Absolutely, I agree 100%. If the jury sees what the officer sees, you have a much better presentation.
We'll be right back with our guests in a minute. Thank you again for being here, guys. Judge Achondo and Ray Duke. Judge Achondo has been on the bench for 16 years, as I've said, and Ray Duke has been with the District Attorney's Office for 17 years. I was talking to Ray about the alcohol level before we took our break, and now let's talk about how that's determined. So what are the ways you determine the alcohol level?
Sure, we have two ways of determining alcohol level in the state of Texas. We have what's called an intoxilizer 9000, which is a breath testing instrument, and we have several in the county. They're actually located at all the regional command centers with the police department, and I believe we have several out with the sheriff's office as well. I think one in Vinton, one at the Montana station, and one in Clint. Anyway, the offender, the defendant, is asked to provide 2 breath samples into the instrument, and then the instrument...
Into the instrument that the policeman has at the car, or do they drive him to these places where...
Okay, it's a very good question, because there's actually 2 different types here, and you brought up a really good point. The first is what we call a portable breath test. Now in Texas, a portable breath test is the results of that are not admissible in court.
Oh.
So what we do is we take them to a local station. For example, Central Regional Command, Pebble Hills, Westside, Mission Valley, Northeast, okay?
And I imagine their car stays where it is because you don't want to say, here, follow me to give a breath test.
Absolutely.
Right.
So what happens with their car, we actually have a tow truck. We'll actually call a towing company in to tow their vehicle away. So we don't leave it there at the scene generally. Okay. Sometimes maybe a family member that's sober will come by and pick up their car. But when we take them to the regional command, we ask them to provide a breath sample into the intoxilizer 9000, which is certified, and the results are admissible in a court of law in Texas. Now, obviously we can't force somebody to blow into an instrument. So what we have to do is, if they refuse, we have to do other things. And those other things would involve taking blood. So in El Paso County, we are a no refusal county. So what does that mean? So if you are asked to provide a breath sample and you refuse, then the officer will work up a search warrant, present that search warrant to a judge. If the judge finds probable cause in that search warrant to believe you were driving while intoxicated, then they will grant the search warrant, and then the officer can take blood from you. And in El Paso County, we actually have a 24-hour nurse at the downtown jail that can draw blood. Now, obviously, sometimes the defendant may be in the hospital. Maybe they had a car crash, and they're in the hospital for medical treatment. We can actually do that at the hospital as well. So we've got two different ways of drawing your blood.
So let me ask, if they don't blow a .08 or above, do you do the blood test anyway, or do you say, oh, we're going to let this guy go?
You know, every case is different. For example, sometimes the police may arrest somebody and they may provide a sample that's below .08. But the officer does not suspect drug use. If they don't suspect drug use and it is below the .08, that case may be declined for prosecution. In the event that it's below .08, but we suspect drugs, then we may get a search warrant to draw their blood so that we can send that blood sample off to Austin for toxicology to see what's in their system.
Right. Do you have any sort of percentages as to what happens when, like if they blow under a .08, okay, you're not drunk?
I don't, because that's truly a case-by-case basis. I really don't have the numbers, and I really can't track those numbers necessarily. But you know, it's up to each individual attorney that screens those cases to make that call. And it really depends on the driving facts, the field sobriety test at the scene, how long after the traffic stop or how long after the crash occurred when the breath test was taken. Because as you know, alcohol dissipates
Right.
out of a body, out of the system. So, you know, over time you're going to become sober. So the longer we wait, the lower the BAC is going to be.
Ken?
A misdemeanor DWI is truly a first-time offense, being arrested and charged. To get to the felony range, the minimum felony would be what we call a state jail felony. That would involve a person driving while intoxicated with a child passenger that's younger than 15 years of age. That'll get you a felony. A state jail...
As it should.
As it should, absolutely, because you shouldn't be driving around with your children
Right.
while intoxicated. The other way would be what we call a DWI third or more. So in that instance, you already have 2 previous DWI convictions, and you go out and you drive while intoxicated again. And that would get you into the felonies as well.
You could have the first DWI that involves not just you being stopped. That would not still be a misdemeanor, would it? I mean, maybe you hurt somebody.
Absolutely. So let's say it's a first DWI, but you hurt somebody and you cause what we call serious bodily injury. And serious bodily injury is, I'm not going to get into the legal definition of it, but essentially
Somebody's hurt pretty badly.
they lose an arm, they lose a leg, they break their hip, things of that nature that are really traumatic injuries. That would get you a felony as well. That's what we call intoxication assault. That's a third-degree felony in Texas. In the unfortunate event, if you cause such bad injuries, and it's called traumatic brain injury,
Right.
where you make somebody into what we call a persistent vegetative state, okay, that actually bumps it up. You don't kill them, but they're in a
Right.
persistent vegetative state. That makes it actually a second-degree felony. And unfortunately, if you go out and you kill somebody because you're intoxicated, you can certainly be charged with intoxication manslaughter, and that's a second-degree felony in Texas. So
And
you're
the
looking at
penalties for those could be jail.
absolutely. You're looking if you go out and you cause someone's death because of your intoxication, you're looking at up to 20 years in prison for that offense.
Let's stay on this topic of penalties. So, talk about some of the things. If someone's convicted of DWI, what are they facing in terms of penalties?
Sure. A DWI first, they're looking anywhere 72 hours. It's not 3 days. It's 72 hours to 180 days in jail. Now, realistically, most people are going to be placed on probation for their first offense because we want to get them the help,
Right.
so they don't go out and repeat this behavior. So that's your first-time offenders. And for your felonies, let me go back to misdemeanors one other time. If you have a BAC that's 0.15 or greater, essentially twice the legal limit.
What's a BAC? Oh, blood alcohol
I
content.
apologize.
Yeah.
Blood alcohol concentration of 0.15 or greater, you could be sentenced up to 365 days in county jail. So it certainly gets much more severe in the penalties.
Right.
For a felony, you could be punished all the way up to life
Wow.
in Texas.
Stuff like losing your license, and ignition interlock, those sort of things.
Absolutely. So in Texas, it's part of the bail conditions, and I'll start out there. If you had a prior DWI arrest and you're arrested again for a DWI, by law, the court must impose an ignition interlock device on that person's vehicle.
Which is what?
An ignition interlock device essentially prevents a person from driving if they detect alcohol. If the ignition interlock device detects alcohol, it will not allow you to start that car. There are other devices out there as well. They're called portable breath test instruments. So we hear this story all the time too. I don't have a car anymore. It's been destroyed because I wrecked it. I don't have access anymore. Yeah. That's fine. Now you're going to have a portable alcohol monitor. So we'll know every day whether you've been drinking or not.
What about losing your license?
Losing your license, absolutely. So on your 40th, after your arrest, you have a temporary driver's license for 40 days. On your 41st day, you're going to lose your license. And if you provide a sample and it's over the legal limit, you're going to lose that for 90 days. If you refuse to provide a sample, you're going to lose it for to 180 days. So it can be kind of severe. Now, there are ways you can get a license after that. You can petition the court
for a hardship
a hardship license, absolutely. But as part of that hardship license, one of the requirements will be an ignition interlock device. So we will know what you're doing.
Yeah, yeah.
Not only the fines and the court costs. You know, if you're convicted of a felony in Texas, you're looking up to $10,000 in the fine alone. Court costs are about $300. Then you've got attorney's fees, probation fees, bonds, ignition interlock fees, driver's license surcharges, you name it, it adds up.
What if somebody can't afford this? What happens?
Becomes a great dilemma for the courts.
Yeah, I bet.
But these are mandated by statute, which is where you see you drive by the freeway and you'll see a sign, a DWI can cost you $17,000.
Yeah.
Well, that's pretty realistic.
That's amazing to me. And as you guys both know, you've kind of, I don't do any of this. You've opened my eyes to this. This time has really zoomed by. I'm already inviting you both back for another time. I mean, I think this was worthwhile. I think DWI is something that is very serious.
It is.
And people now, I think, are taking it more seriously than they had in the past. But I want to thank you both for coming and opening up everybody's eyes. And I think the viewers are really educated about this.
Well, thank you, Bob, for having both of us. We truly appreciate it.
We certainly want everybody to be safe, and we thank you for allowing us to come here and share some of this information with your viewers.
Gentlemen, thank you very much.
Thank you, sir.